All right, we should be there soon. And we are now live. Welcome everyone again. So today we are doing a training with Cora Metric Chen from Take Root Justice. She is a lawyer, and today we are doing a training on harassment, particularly by landlords. So harassment and housing court, what steps you can do, how to address it. So I'm gonna give it over to Cora. Thank you so much for being here with us today.
Thanks, Nipa. Thanks for having me. Last time I did this presentation, I was suffering from allergies too and losing my voice, so hopefully this presentation is even better than last time. We're talking today about harassment, landlord harassment of tenants. My name is Cora. I'm a staff attorney on the housing unit at Take Root Justice. I see that we have a lot of housing advocates in the room right now, which is great. I see a lot of people from NICA, Homebase, I Love, and Woodside on the Move. This presentation I wrote it to be informative for tenants, and I believe that it should also be informative for tenant advocates as well. If you're a lawyer who's been practicing tenants' rights for a while in New York City, this is going to be barely an introduction for you at the 101 level. So it's not an advanced presentation on harassment, it's a basic presentation on harassment. I think a lot of the people in the room are going to know a lot of the content already, and hopefully this will just help you flesh things out and answer any questions you might have. Uh, 1 second to figure out how I work this. Okay. So my organization is called Take Root Justice. We're an organization who specifically works with organized tenant groups, such as tenant associations and tenant unions. When we talk about landlord harassment, that has a specific meaning to us. It's a meaning that sort of spans the divide between the legal definition and the practical definition experienced by those of us who are tenants actually on the ground. To us, we think of landlord harassment in this context, which is that many landlords illegally harass and intimidate low-income and rent-stabilized tenants to drive them out in favor of higher-paying tenants. So we see harassment as part of the context of gentrification and the commodification of housing, and against this more humanist stance of housing as a human right. Before we get into this, one thing that I'd like to preface that I think is really important for people who are experiencing landlord harassment is that you're not alone in experiencing landlord harassment when you do. And in particular, if your landlord's harassing you, that landlord is probably also harassing other people in the building or other people in other buildings that landlord owns. So you are stronger together. The sort of avenues and remedies that I offer in this presentation are very legalistic. I don't have the expertise to offer organizing strategies, but don't make the mistake that I often make as somebody who's been trained in the law. The law is not the only way. There are certain steps you have to take if you want to achieve a legal result, but you don't have to take those steps, and those aren't the only steps you have to take to achieve your result in general. You can organize, you can take direct actions. So think of this presentation as just being a couple of tools in a larger toolkit set. So when we are talking about landlord harassment, there are many, many ways that a person can harass another person, a group can harass an individual. Landlord harassment is specifically harassment by a landlord or somebody who works for the landlord. Someone who is hired by the landlord, contracted by the landlord, whose employment is within the landlord's control. So I'm going to use the word landlord a lot here, but when you hear me use that, I am also referring to, for example, a superintendent of a building or somebody who's hired to be a janitor. And landlord harassment against tenants in particular. You'll hear me use the word tenants. I also mean people who have a legal right to occupy a unit. So you don't have to be the person with your name on the lease to experience landlord harassment and to have a claim against your landlord for landlord harassment. You can be the child of somebody whose name is on the lease. You can be the roommate. And it's harassment when that behavior is intended to get you to move out or to get you to give up some sort of tenant right that you have or right that you have in relation to your occupancy of the unit. A lot of people overlook this second part. It's not only harassment when the landlord is trying to drive you out. It doesn't have to be that the landlord is trying to push you out. It could be that the landlord just wants you to stop complaining. It could be that the landlord wants you to stop organizing. If the landlord is trying to get you to waive your right to complain or waive your right to repairs, waive your right to organize, that could also be harassment. And the reason why I start with this slide is just to distinguish the type of harassment we're talking about in this presentation from the many, many other kinds of harassment that people can experience. So, for example, if your landlord is harassing you over an unrelated matter, something that doesn't have to do with housing, maybe you also both have your kids in the same school and there's some sort of beef between families. If the landlord's behavior is not intended to cause you to waive some sort of right in relation to the unit, then it's not technically landlord harassment for the purposes of today's presentation. Let's start with what the law sees as being encompassed by landlord harassment. There are many, the The main source of law on landlord harassment in New York City is the New York City Housing Maintenance Code. And the Housing Maintenance Code has defined examples of harassment, laid out examples of harassment, and there are many of them, many different things that the law sees as harassment. Some of them are more obvious than others, the things that we would think of right away when we think of harassment. If the landlord or the landlord's employees use force against you or threaten to use force against you, if they take your stuff out of the house, if they make it hard for you to get in and out of your apartment, like replacing the locks without telling you, or interfering with the door in some way, or if they're aggressively contacting you. For instance, they're showing up at your house outside of regular hours, or they're contacting you repeatedly, including on weekends, is all a form of harassment. And I think that's something that we all know intuitively. I think the important and useful thing about the New York City Harassment Code is that it goes beyond that, or the Housing Maintenance Code is that it goes beyond that in defining harassment, including things that we might not automatically think of as harassment. So if you threaten a person based off of what we call a protected status, an identity like how old they are, what their race is, immigration status, sexual orientation. If your landlord threatens you based off of these things, that's also harassment. And we'll talk about at the end of the presentation what else it might be besides harassment. Something that is really relevant and important right now is that if your landlord has a government issued ID on file for you, they are allowed to ask for one form of government issued ID. But once they have that form, if they ask for other forms as well, that can also be harassment. And this is intended to protect people who the landlord might be inclined to try to force to prove their citizenship. You don't have to prove that you're a citizen to rent in New York City. And if your landlord tries to force you to do that, that could be landlord harassment. If the landlord gives you false information about the unit, specifically if they tell you it's not rent stabilized and it is, or vice versa, that could be harassment. And if the landlord has started suing you in eviction cases over and over, and those eviction cases have no purpose, no real logic behind them, then that could also be harassment. I don't mean if you keep falling behind on rent and the landlord keeps suing you. Uh, I mean, if the landlord is inventing that you've fallen behind on rent or saying that you've done something that you haven't and suing you for that, that could be harassment. So those are some forms of harassment that are a little less basic. There's also a whole sort of bucket of harassment that the Housing Maintenance Code defines that are related to construction. I'm not going to get too deeply into them right now. We could do an entire separate presentation on construction as harassment, but just understand that if the landlord's not complying with legal requirements and tenant protections in the course of doing construction, then that can be construction as harassment, and it happens a lot. Tenants have protections when construction is going on in their building, and landlords often fail to follow them. Something that we also see is that when a landlord is forced to make repairs, they'll come in over and over again, make a mess, barely do anything, and leave. Sometimes that could rise to the level of construction as harassment. And although it's not the first thing that we might think of when we think of landlord harassment, I think for as a housing practitioner, the most common type of harassment that we see or that I see in my practice is repeated failures to make repairs. And this actually makes a lot of sense. What better way to drive somebody out of a unit or to force them to stop complaining about repair problems than to just do nothing and let the unit fall into disrepair. This also rises to the level of harassment. And it can be hard to get judges to um, make a finding of harassment based off of repeated failures to repair, but it's possible. And it really amps up your average lawsuit for repairs to also allege that landlord harassment has occurred. Finally, there's a bucket of actions that a landlord might take in relation to trying to buy you out that could constitute harassment. If they contact you repeatedly to try to buy you out of your apartment and you've told them in writing that you don't want that, that could be harassment. And if they're essentially bullying you into accepting a buyout offer, that's harassment as well. What's really important here is that everything that I've just named above is the specifically delineated types of harassment in the Housing Maintenance Code, but the Housing Maintenance Code deliberately provides a catch-all for harassment that doesn't easily fall into those categories. And that catch-all is defined as repeated significant acts of any kind, as long as they substantially interfere with the peace and quiet of an occupant. So there's all these specific ways that a landlord might harass a tenant, and then there's this catch-all category for the ways that fall outside of that. So if you don't see the type of harassment that you're worried about on the list above, don't worry, maybe it falls into the catch-all. So I've just gone through and talked about ways that we can think about harassment, actions that can arise to the level of harassment. I'm going to talk about HP actions, harassment lawsuits, and housing court, because they're the most obvious recourse when a landlord is harassing you. And I'm going to go through HP action, first talking about what they can do for you, and then talking about what the steps of an HP action are. Again, this presentation is intended for it's intended to be something that tenants themselves can understand and act on. So I'm going to be using very basic language and trying to open up the process of HP actions in housing court to be something that advocates can explain to tenants that tenants can understand on their own. After we go through HP actions, I'll also talk about other types of recourses and remedies that a tenant experiencing landlord harassment might have. This is by far from, it is by no means the only recourse that a tenant has when a landlord is harassing them, but it's the most available one. Before we go further, I, a lot of my clients, they've experienced really horrible things at the hands of their landlord. They're really angry, they're fired up, and they want a lot of different types of remedies or relief from the landlord. And an HV action is good for some things and not as good for others. Namely, they're good for getting an order from a judge to tell the landlord to stop the harassment. And if the landlord violates that order, they're good at punishing the landlord via fines for violating the order. They are not good for personal compensation, the harm that a tenant has suffered. And they're especially not good if, for instance, a flood has destroyed the tenant's personal belongings, or their mold has destroyed clothes. They will not compensate a tenant for destroyed personal belongings, and that's a frustration that I've encountered a lot. I'm going to talk very briefly at the end of this about what types of actions a tenant can take to try to get compensated for personal belongings. What you can get out of an HV action are a number of things. You can get injunctive relief. Injunctive relief is an order from a court telling a person to cease doing something or to telling a person to comply with something. And this is the primary form of relief that an HP action in housing court is intended to provide. You can also get civil penalties. The landlord might have to pay the city civil penalties if it's found to have harassed the tenants. Anywhere between 2,000 for a single instance to 10,000 per unit for repeat instances of harassment. And if harassment has been found previously, then the amount goes up. It is possible to get compensatory damages, that is, money paid directly to the tenant for harassment, but it can be hard to get. It is possible. It's not a great, this type of lawsuit is not a great vehicle for that. And again, it won't compensate the tenant for damaged personal belongings or things like that. It will compensate the tenant for the loss of the habitability of the home, for example. And it's, again, not, there's, the pathway to getting compensatory damages in an HB action is not very direct. If you get compensatory damages, you can also get attorney's fees. A tenant can also say, look, I'm not interested in getting compensatory damages. I'll take $1,000 though, and that's another option. It's also possible to get the judge to order punitive damages to punish the landlord on top of the civil penalty. And an additional thing that you can get out of an HP action is if the landlord violates the injunction, violates the order from the court, you can get actual damages. You might get your costs and expenses reimbursed. You also get a statutory fine of $250. And again, you might get punitive damages. This is all just a complicated way of saying that the number one form of relief that you can get from an HP action is an order from the judge telling the landlord to stop doing that. And then the enforcement mechanism, the teeth behind that is the civil penalties, or the fact that the landlord might be fined if they don't stop. HB actions are something that a tenant can do on their own. Anybody can go into housing court and file an HB action, whether or not they have a landlord, or whether or not they have a lawyer, I'm sorry. But what are some things that will help make your case easier if you're not represented or if you are represented in an HP action? Remember that I was delineating all of these different kinds of harassment. If the type of harassment you're experiencing falls clearly into one of those categories, you're going to have an easier time proving harassment in housing court than you will if it falls into the catch-all. If it falls into the catch-all, what you need to do is prove that the landlord's actions are repeated and that they substantially interfere with the peace and quiet of your living situation. So it will help if it is in one of the delineated categories rather than the catch-all. It will also help if you live in a building with 3 or more units, and I'll talk about that a little bit more at the end of the presentation. Being willing to put in work is a really important component of the success of an HP action. I know that it's hard to go to court when you're a working person who doesn't get days off that easily and whose income is precious. But if you're willing to show up and testify and you make it to all your court dates, that's going to be a huge bonus to your court case. Working with other tenants to file is also going to be a huge difference. It will also make it easier to sort of distribute the labor of going to court. But just one person suing a landlord alone in an HB action might not ruffle the landlord's feathers that much. If you have 7 out of 30 units in a building, even filing an HP action together, then that might ruffle the landlord's feathers a little bit more. And imagine if you have the entire building teaming up to sue the landlord. Finally, document everything. And I'll return to this point a couple of times in the presentation, but judges are really interested in proof. And a little bit more of a cynical way to put that is that judges are really interested in getting rid of cases if they can. And if they're not backed up by proof, then if the case is not backed up by proof, then that gives the judge an excuse to get rid of your case. If you have a harassment claim that's based off of repeated failures to repair, having HPD violations placed in advance, so you call 311, HPD comes out and they say, yes, I see this is a problem, and they issue a violation for the landlord. Having those placed in advance is so important to the case that it's almost a requirement. I say here that it's a requirement. It's going to be very hard to win a harassment case based off of repeated failures to repair if you don't have them. But it's possible if you're willing to go to court and testify instead. So let me take you through the steps of an HP action. Like I said, anybody can go to court and file an HP action. You don't have to have a lawyer. What might make your case a lot stronger is to have evidence or proof. What constitutes evidence or proof? Again, having government records is going to be one of the most compelling forms of evidence to a judge. For instance, HBD violations, again, those are the violations generated by calling 311 and having a city inspector come to your building. DOB violations, very similar, but you're reaching out to DOB for building structural problems or things that are less individual apartment problems. You could have a police report if the type of harassment that you're complaining of is the landlord threatening you or using physical force against you. I put an asterisk here because a police report, having an interaction with the police is not an option that's available to everybody. People who are more marginalized by society, who have higher risk levels of certain kinds, might not actually feasibly be able to go to the police in a safe way. So I put an asterisk here. If it's possible for you to go to the police, if you're comfortable doing that, and you're experiencing something that a police report could be generated about, again, threats of force, use of force, interference with personal belongings, the landlord changing the lock on the door, a police report will be a compelling record to a judge. If you don't go to the government agencies about the harassment that you're experiencing, or if it's not the type of thing that you can call 311 about or call the police about, that's okay. The next best thing is written records of any kind. So I always recommend that if you're having a conversation with the property manager and the property manager tells you something, even if they refuse to put it in writing or they refuse to text you about it, and I have plenty of clients who say, oh, but my landlord knows better than to text me about this. One thing that you can do is just follow up immediately after you have the conversation in text or in email and say, just confirming what we talked about today to summarize and put that information into a summary so that it's written. There's a record that, at least there's a record that a conversation occurred. And besides that, if the landlord's actually emailing you, texting you, the property manager, the super, all of that could be useful as proof. Obviously, videos, a lot of people have the good instinct to take out their phone and take a video if the landlord is being threatening, if workers are uh, causing destruction in an apartment. And finally, if all else fails, you don't have any of this sort of hard evidence, concrete evidence, you might be able to just go to court and testify. I put this last because I think we've all seen uh, shows where we see trials if we haven't actually watched a trial go down. People will try to shred witness credibility and make you seem unreliable. If you can be consistent, direct, and forthright in your testimony, then you might win a battle of my word against his word. But testimony creates an opening for the landlord's lawyer to try to tear you down, and even at best, create pits your word against the word of the landlord's employees. So it's useful to testify, it's helpful to testify, but it's not the best option if that's all your case is based on. So step one, gather your evidence. Think about what you have from this list and prep it and get ready to go to court. Step two, I'm not going to go through all of these too closely, but basically you go to your local housing court and you go to the clerk's window and you say, I want to start an HP action for harassment. The clerk should assist you in filling out some forms. If you are a low-income person, you can get a fee waiver. If you're not, you will need $45. And you fill out the forms with the explanation of the circumstances of the harassment. If you fill out an inspection request, this is for if there are repair problems in the apartment. An inspector will come on an assigned date. You don't get to choose the date. You must make sure to be home on that date. And you'll get a court date maybe 10 days after the inspection. Courts move at very different and varying rates when it comes to harassment cases, so that's not a guarantee, but usually around 10 days later. And it's up to you to take all of that initial paperwork and serve it on the landlord. You should, if you have questions about how to do that correctly, you should talk to the clerk about it. They should give you detailed instructions. Keep all of the receipts that you possibly get in relation to the mailing of these papers, because that's another way that a judge who wants to get rid of the case can easily get rid of your case. They can say, doesn't look like you served this properly, so even though you did all this work, you have to start over again and this case is gone. Goodbye. When you go to court, you probably aren't going to get a major decision on the first day. That doesn't mean you shouldn't fight for it. Fight for it. I think that going strong right out the bat is a good idea. Yeah. Often the landlord doesn't show up. That's really annoying. You can ask for a default judgment against the landlord. The judge might instead just postpone. And you'll probably get future court dates assigned out of the first court date. The court dates are usually, I would guess, like 3 weeks apart. Again, it depends on how busy the court is. And the things that you might ask for at your first court date or at subsequent court dates are that the landlord uh, agrees that it will stop engaging in the harassing behavior. And if it's a case based off of repairs, you could get the judge to order the landlord to fix any 311 or HPD violations that are open. What does winning an HP action look like? There's two different things that could count as a win. If the landlord agrees to stop doing the harassing behavior on paper in a settlement agreement, that's a win. Or if the landlord won't agree to do that, and you have to keep going back to court to prove that it's been happening to the judge, and the judge, and you finally convince a judge to issue an order telling the landlord to stop doing that, that's the other way to win. One is not necessarily better than the other. As long as the settlement is signed by a judge, it has the same force as the order, which is also signed by a judge. They're both orders of the court. So you could win via settling, or you could win via convincing the judge and getting an order from the judge. A lot of people will stop there, and I think for a lot of people, that's why HP actions have a reputation for being ineffective. HPD itself will sometimes sue landlords for harassing tenants or for failing to repair. And HPD, the city agency, often just stops at the order stage. It gets the order. The landlord's like, okay, I have to follow the order, I guess. And then the landlord doesn't follow the order. The tenants are in the same situation before, and there's been this whole court process, and everyone's frustrated. If the landlord violates the court order, you have the opportunity to hold the landlord in contempt of court. It's often pretty confusing to a tenant because technically, once you get the order, once you get the settlement, the case is over. There aren't any other court dates. It's not on the court calendar. There's no other court appointment. It's up to the tenant to document the landlord's violation of the order, take that information back to court, go back to the window, and file an order to show cause to hold the landlord in contempt for violating the order. Contempt orders are taken pretty seriously by courts and taken pretty seriously by landlords. And this is the stage at which a judge is more likely to penalize the landlord with fines or even punitive damages. So this is a step that is optional. If the landlord obeys the order, then you're good, you've won your case. If the landlord disobeys the order, then you might want to follow up with contempt. And that's kind of the lifespan of an HP action. This is essentially the last part of the presentation, and the purpose is to go through things that might kind of be complicating factors. You might be thinking, well, what about rent stabilized tenants? What about people who live in smaller homes? What about other things that kind of look like harassment, but I didn't talk about yet? This is my catch-all for additional things, and I hope that it clarifies things rather than makes them muddled or complicated. If it leaves you muddled, let's talk about it in the questions. I mentioned earlier that one of the things that would make it easy to win an HP harassment case is if you live in a building with 3 or more units. Why did I say that? Under the Housing Maintenance Code, the types of harassment that I laid out, that are laid out in the Housing Maintenance Code, and any harassment that falls into the catch-all. If you live in a building with 3 or more units, it is assumed in the law that if a landlord's doing any of those types of things, that the landlord has an intent to make you waive your tenant's rights, or some of your tenant's rights, or to force you out of the building. And to win in an HP action, the landlord must have an intent. So again, if you're living in a building with three or more units, you don't really have to bother with the question of, did the landlord really mean to force me out? Did the landlord really mean to make me waive my rights? Because it will be automatically assumed as long as the landlord has engaged in harassing behaviors that fall into the definitions that I was talking about. But if you live in a unit in a building with just one unit or just two, then even if the landlord does one of those specific things, even if the landlord asks you for an ID when they already have an ID on file, or shows up at your house repeatedly on the weekends, even though you've asked them not to, then to win your harassment case, you will have to prove that the landlord is doing those things with the intent to either push you out of your home or cause you to waive your rights. So anybody who's filing an HB claim for harassment or any claim for harassment needs to document, document, document. If you live in a 1 to 2 unit building, you need to document even more. And the things that you're really looking for are documentation of the landlord's intent to push you out. So this can be really hard to prove, short of the landlord actually saying to your face or in writing, like, I'm doing this because I want you gone. But landlords do say all sorts of things. Just try to make sure to catch as many things that the landlord is saying and doing in documentation as possible. So if you live in a small building, you can still file a harassment claim against your landlord. Harassment is still illegal. It's just a little bit harder because you'll have to prove the landlord's intent as well as the fact that the landlord engaged in the behavior. Again, if you live in a larger building, 3 or more units, all you have to prove is that the landlord engaged in the behavior. I will take a quick second here to note that part of the reason why this carve-out exists is because there's a great deal of mythology in landlord-tenant circles about small landlords. People feel really bad for small landlords, and small landlords take up a lot of the conversation about housing. However, in New York City, 13%, only 13% of all apartments in New York City are owned by a landlord who has 10 units or less. Most of New York City's housing stock is owned by very large landlords. So it's a little bit frustrating that this carve out exists, right? Like, even if your landlord has only got a couple units, they can still harass you. They're just as likely to harass you as a large landlord. But there's this carve out that makes it harder for you because I think of this because of this sympathy for small landlords. You might be thinking, what do I do if the landlord says something racist to me or does something that's actually criminal to me or destroys my belongings? I said at the beginning that some of these things, for instance, destruction of personal property, might not be the best basis for a harassment lawsuit. So in this slide, I'm talking about 3 different things that could be harassment. You could file a case about them in housing court, but they might be better suited to a different kind of case. Something that I haven't talked much about is discrimination. To me, as a lawyer, and specifically as a tenants' rights lawyer, discrimination is a different kind of case. Can it be harassment? Absolutely. It can be harassment and you can sue your landlord for it in housing court. And however, there might be better avenues to pursue a discrimination claim than an HP action in housing court. So what is discrimination? Discrimination from a landlord is if the landlord, or by the way, a neighbor, take some sort of negative action against you. It has to be an action. It has to be coupled by an action. It can't just be they said something. Um, Based off of your protected status. And what our protected status is, some examples are race, gender identity, national origin, citizenship status, age, sexual orientation, height and weight are protected statuses in New York City. Disability is a protected status. If you think that a landlord is taking a negative action against you based off of something like this, I highly recommend that you make a complaint to the New York City Commission on Human Rights. That doesn't mean you shouldn't also file an HP action, but I have a feeling that NYCCHR will provide a swifter and more direct avenue towards some sort of compensation for you. Similarly, if the landlord uses force against you, threatens to use force against you, is stalking you, there's unwanted touching, sexual harassment. Is that landlord harassment? Can you sue in housing court? Absolutely. It's also technically a crime. These things are crimes. And if you are looking for something more than an order from a housing court judge to tell your landlord to stop, then again, this is something you might want to report to the police, and it would end up in criminal court. This is with the same caveat that going to the cops is not always an option for everyone. But just to sort of draw out that these two things can both be harassment and they're also something else. Finally, like I said, I have clients coming to me telling me that the landlord's negligent or deliberate actions have resulted in damage to their personal belongings. And this is not as easily a straightforward case of harassment in housing court. Could it be? Yes. Will you get compensation for your personal belongings? Probably not. But you can go to housing court about it. The better thing to do if you want compensation for your personal belongings is if the damage consists of $10,000 or less in total, go to small claims court. You don't need a lawyer to go to small claims court. You can file a claim on your own. You will need receipts and documentation of the fact that you own these items and that they were of value. So that can be really annoying because who keeps their receipts from Target for their furniture or their clothes? But uh, you can try to go to small claims court about it. If it's something uh, more more serious with a higher monetary value, for instance, like a slip and fall, that is the best vehicle for that is a personal injury lawsuit. And I don't know anything about personal injury lawsuits. I am not a torts lawyer, but when I have clients who come to me and say, I got hurt because of something the landlord did, I recommend that they try to find a personal injury lawyer. So again, to summarize, these are three things that could constitute harassment. You could file a claim about them in housing court, and they also are other things as well. I get a lot of questions about what if it's not the landlord? What if it's my neighbors? What if it's the tenants above me, the ones across the hall? Their children are really loud. They play music at all hours. The cops keep getting called over here. I really don't like talking about problems with neighbors because, as a lawyer, this is not something that the law is made for. The law is not made for resolving interpersonal disputes. Uh, the types of justice that arise from the interactions that you have with your neighbors are not the types of loss of justice that the law is set up to provide. This is something that comes more from society and interpersonal interactions. And relatedly, the legal recourses for issues with your neighbors are not that good. If your neighbors are discriminating against you for protected status reasons, if they're being hostile to you, making it hard for you to live where you're living, uh, and it's because of your race or your sexual orientation, then again, that falls into the discrimination category, and I'd recommend speaking to NYCCHR about it. If it's something else, something nowadays more typical, like a noise complaint, the number one step is try to resolve it with the people themselves. Mention it to the landlord, mention it to the neighbors, as long as you feel safe doing so. And I understand that there are situations where you wouldn't feel safe doing so, but it's going to be hard to proceed if you don't first actually ask the person to stop. And you can also make a noise complaint to 311, and there are a lot of other types of complaints that you can make to 311 about your neighbors. Step two, if that doesn't work, if your landlord doesn't intervene, if the neighbors don't stop on their own, step two might be mediation. And I recommend mediation over legal action because it's more likely to be effective. There's New York City citywide mediation programs. You can find a mediation service in any borough. I hear, though I didn't find the citation for it, but I remember a statistic that like 80% of people who go into mediation leave mediation satisfied. So that's the next step that I would recommend taking. If you must, if nothing else is working, you can consider legal action against your neighbors. You can sue your landlord for problems with your neighbor. It's really hard. Uh, Notably, noise complaints are considered one of the hardest types of harassment to enforce in housing court. It's very hard to document that the noise is very loud and the noise comes and goes. It's hard for the judge or the city to inspect for, etc. But you can sue your landlord who has a responsibility to take reasonable steps to make sure that you live in a peaceful environment. Often these cases don't succeed. The landlord easily shows that they've done what they can. They took reasonable steps, and it's difficult to show that the neighbors continue to persist or that it rises to the level that's considered harassment. You can also sue the neighbor directly in small claims court or in New York City civil courts. What about rent stabilized tenants? Are their rights different from what I've just been talking about? No, they're not different, but they have extra rights. So if you or your client lives in a rent stabilized unit, not only do you have recourse to the New York City Housing Maintenance Code, which all of the law on harassment that I've just been speaking about is drawn from, but you have a very similar additional law uh, from New York City or New York rent stabilization law. It defines harassment as something in a way that's very similar to the housing maintenance code. It's pretty broadly defined. Anything that interferes with or disturbs the privacy, comfort, peace, repose, or quiet enjoyment of the tenant, or is intended to cause the tenant to vacate or not exercise a right under rent stabilization code. So it's a little bit easier to prove for than in the housing maintenance code because you don't have to prove intent. Uh, if you are a rent stabilized tenant, you can do anything that I've already talked about to enforce your rights and stop the landlord from harassing you, including you can go to housing court and file an HP harassment to sue the or HP action to sue the landlord for harassment. You can also choose to go to DHCR instead by filling out a harassment claim or harassment complaint form. It's available online and you can mail it to DHCR or bring it to them. DHCR will look into your harassment claim. It won't be the same as going to court. It might result in a hearing at Gertz Plaza. It won't be as formal as a court hearing, and there won't be as many of them. Filing with DHCR is kind of like a one-shot thing. You have one chance to prove harassment, and that's it. If DHCR finds that the landlord has harassed, it will impose a civil penalty on the landlord, very similar to the civil penalties that could be imposed in housing court. I believe it ranges from $3,000 to $10,000 and is stepped up if the landlord has already been found to engage in harassment in years prior. Why would you want to do this instead of going to housing court? It is a little bit easier and less involved. Why would you want to go to housing court rather than DHCR? It's more hands-on, you have more control over the process, and it's more accommodating to large groups of tenants and to other sort of direct action or organizing actions. Something that often gets conflated with harassment and is very similar to harassment is interference with a tenant's right to organize. Under New York state law, tenants have a right to organize. They have a right to meet in the common areas of the building, to talk to their neighbors, to form a tenants association, to complain, to rent strike. They have a right to put flyers under people's doors. If a landlord interferes with this, is it harassment? Arguably, yes. Could you go to housing court about it, file an HB action? Yes, you could. But a swifter thing might be, say the landlord calls the police on your tenants association. That's illegal. You can go to the Attorney General about it. There's a tenant protection unit. I believe we might have somebody in the room who knows more about this, but getting the Attorney General's eyes on what the landlord is doing can be a really swift and effective way to sort of startle the landlord into demonstrating that you know your rights and getting the landlord to stop. You can also file an emergency order to show cause not in housing court, but in New York Supreme Court, which is the standard civil level court. To get an injunction, again, that's an order from a judge telling the landlord to stop. And both of these two methods might be a swifter way towards getting the landlord to stop than a harassment case in housing court. The second of these two methods, getting an injunction in New York Supreme Court, would probably require that you have legal counsel to do that. But you could reach out to a tenants' rights lawyer and see if somebody would take the case. Finally, you might be thinking, okay, so I hear that I can file a case against my landlord for harassing me, but I'm afraid of my landlord. They're harassing me, and I'm worried it's just going to get worse. There are laws in New York City against retaliation from the landlord. So if you speak up about your rights, you actually gain additional protections under the law versus if you don't speak up. If you've asked your landlord for repairs, if you called 311, if you filed an HP action in housing court, for 1 year after you've done that, if your landlord tries to evict you, you have a defense to that lawsuit. You can say, this is illegal retaliation against me for exercising my rights. The defense is not automatic, but it is presumed. The law will assume it. Unless you're talking about a non-payment eviction proceeding where you've actually fallen behind on rent. And this has to do with this note at the bottom of this slide here. If the landlord has a non-retaliatory reason for trying to evict you, for instance, if you've fallen behind, it's going to be a little harder to prove that the lawsuit is about retaliation and not about the fact that you owe rent money. So the defense of retaliation is a protection in law for people who up against their landlord to assert their rights. It is not an independent basis for a lawsuit. So if the landlord is acting, is threatening you in some way, because you've exercised your rights, that would be it might be a harassment lawsuit. There is no such thing as a retaliation lawsuit. But if the landlord takes legal action against you, you can defend yourself against the legal action by using the defense of illegal retaliation. And this is all just to say that in some ways, and standing, speaking up and standing up for your rights can put you in a stronger legal position than if you just say nothing. Finally, among the many things that we touched on today, there are additional resources available. HBD Online, if you haven't used it before, is really useful to look up your address or the address of your clients, figure out the names of the landlord, the manager's addresses. If you're going to start an HP action, that's where you're going to find that information. And to follow up on violations, then 311 placed. Who owns what? New York City. You can find out even more about your building, how many units there are, when it was built, um, how many other, or approximately how many other units the landlord owns. Met Council on Housing has some useful instructions on how to file an HP action. It's not specific to harassment, but it can help walk you through how to do that if this presentation was insufficient. DHCR has information on harassment specifically for rent-stabilized tenants, since DHCR is a New York agency that oversees rent stabilization. The fact sheet is really useful. If you think that your landlord or your neighbor is discriminating against you based off of protected status, the New York City Commission on Human Rights has a help page specifically for tenants/residents that helps you understand what types of claims you might have and how to file them, what you might get out of them. And if you are having a dispute with your neighbor or tenant across the hall or somebody in your building, there's 311 has a list of offices that can assist with mediation in all of the boroughs. So those are some resources that I've linked in this last slide. And I think we can take questions now.
Yes, just remember we cannot answer case-specific questions, so we will be going over general. If you have case-specific questions, you can call Housing Court Answers at 212-962-4795. But one question I got, and I'm not sure if you can answer this. I'd be interested in the intersection of harassment and good cause eviction. For example, in the case where a landlord is aware that a unit qualifies for good cause eviction and yet fails to provide the notice, the 30, 60 day, 90-day notice, and refuses to accept the rent.
Good cause is such a new law that I'm not aware of harassment cases that have been tried based off of violations of good cause, but I would argue this is going to be my answer to a lot of the things that people ask. I would argue that it might fall into the catch-all by rising to the level of something that seriously interferes with a tenant's peace and quiet. Um, Good cause, I'm admittedly a little bit behind in following the changes that Good Cause has created, but I'm pretty sure that it provides its own recourse for if the fails to provide these notices. For instance, if the landlord tries to sue you in a holdover, you would have a defense. And if the landlord sues you in a non-pay, you would have a defense to the amount of rent. So I guess my answer is that I'm not aware if affirmative litigation, like bringing a case, has been tried yet based off of good cause violations. It seems to me that it would be possible. And good cause does provide you with defenses in law, kind of parallel to how retaliation is a defense in law that you can raise if the landlord tries to evict you based off of refusing to sign a lease or staying past your lease term or not paying the full amount of your rent.
Okay. So our next question is, when filling out an HP action for harassment, what is the exact wording we need to put on the HP form?
Um, I wish we could. I can't share anything else right now because I don't know what client information is up on my computer. Is there a chance that you could, let me see if I have that more specific information in the slide itself. So there's a DHCR complaint form, which is available online, but I think the question is about the HP form. I don't believe that the HP form is specific to harassment. I think there's just a general order to show cause for any type of HP action, and more typically, those are repair cases. I think that you would want to handwrite on the form what the landlord has done that arises that you are saying constitutes harassment. And if the form is insufficient to write that information out, I would typewrite or handwrite it and include it as an attachment. You don't have to include all the facts of your case. You just have to include enough specifics that you're not just saying something redundant, like, I'm filing a harassment lawsuit because the landlord has harassed me. It would need to be a little bit more specific, like, I'm filing a harassment lawsuit because the landlord has made repeated attempts to contact me, for instance, on X date. And you don't have to put all the dates, just as an example, but you do need some specifics. Does that answer the question?
I can check also if they follow up. Um, but the next question is, from your experience, do landlords stop harassing the tenant after the court's first order to stop? Or do most tenants have to go back to court to reopen the case? In other words, should tenants have the expectation that they will have to go back to court to reopen their harassment case?
Just one more thing on the initial the question prior. The housing court does not make do this, but you can, in your order to show cause, like attach photos and other documentary evidence. You can just submit it with the rest of the order to show cause. You don't have to, again, just to start the case. You might not want to, but you can, and the housing court does not make that obvious. Should tenants have the expectation that they will have to follow up uh, a court order with a contempt order? Meaning, should they expect the landlord to violate the court order? I think it completely depends on the landlord and the just how shameless the landlord is. So the cynical part of me says yes, like be prepared. From a practical standpoint, I think there are plenty of landlords who would just be shocked by a court order at all and would worry about violating it and would comply. But there are also plenty of landlords who would violate the court order. And I think it's good to be prepared. And I think that often when landlords violate the court order, tenants are left scratching their heads, like, what do I do now? And there's something very obvious that you can do, which is follow up with contempt.
Okay, I think somebody said, if I am not mistaken, while signing in, I saw an email where to contact you if you could send via messages.
Say that again?
I believe they said that when they were signing in, they saw an email where to contact you if you could provide um via messages.
Oh, sure. I can put my contact information in the chat. I'll just go back to can you provide the number of the H? Okay, so one moment. That's my email if you need to follow up with me. The number of the HCR harassment form I linked it. Sorry about flashing through the slides. No. So the DHCR harassment complaint form is called an RA 60H. See if I can copy the link. Here we go.
I don't know if you're opening it, but if it's
Oh, I just
yeah.
pasted the link in the chat.
Okay, great. Somebody else asks, harassment as a counterclaim for non-payment. Will the courts hear?
Oh, that's a good question. Housing courts always have the discretion to kind of chop off your counterclaims. So you can raise any counterclaim you want that's related to your housing against any type of eviction case. But the judge doesn't have to actually adjudicate or oversee the issue of your counterclaim unless it's inextricably related to the case that was originally brought against you. So if your non-payment eviction case, if your landlord brings a non-payment eviction case against you and you respond with a counterclaim for harassment based off of failures to repair, which have something to do with the true value of the rent in the building, I would argue that the judge should allow those claims to continue, should oversee those claims. If you file a harassment claim, if you counterclaim for harassment based off of something else that has less of a direct relationship to the value of the apartment, they might be less likely to do it. If you're filing harassment for instance, falsely or illegally, repeatedly falsely or illegally claiming that the rent is something it's not, or if you're, I think the most direct example is if the non-payment claim itself is part of a course of harassment, then the judge should definitely oversee those counterclaims. Uh, like I said before, judges love to get rid of cases. They have a lot of cases that they're dealing with, and they want them to be as simple as possible. So I would expect a judge to err on the side of not hearing your counterclaims. As a lawyer, I find myself having to go above and beyond to just try to get a judge to even take a look at counterclaims. And I would expect the judge, if you're a pro se tenant, if you're not represented, you're going to really have to advocate for yourself in front of the court attorney and in front of the judge to get the judge to pay attention to the fact that you even have counterclaimed. They might overlook it. I have the most cynical view on housing court.
Somebody asks, what else besides HP action? I'm not understanding the contact, but I don't know if you got it, if they could clarify, unless you understand, Cora.
If the question is what else can a tenant do besides bringing an HP action, the answer is a lot of things, right? There are a lot of non-legal actions that a tenant can take against a landlord who's harassing them. You can leave them bad reviews on social media. Just make sure you're telling the truth because you don't want them to say that you're slandering them. Uh, you can organize with other tenants to get the press involved, to get media, to have rallies, to go to the landlord's house to demonstrate in front of their home, uh, to shame them. I've known tenant organizations went to the banks that mortgaged the landlord's property and told them what shameful things the landlord was doing. There are many, many things that a tenant can do. And if you're asking specifically about what other legal recourse, besides an HB action, you can do the same. You can file the same type of case, the exact same type of case in Supreme Court rather than in housing court. It would no longer be called an HB action, but it would be a lawsuit against the landlord for harassment. I'm not sure why you would want to do that. It would take longer, uh, but you don't have to do it in housing court if you don't want to. And if you're rent stabilized, you could do a DHCR harassment complaint instead of an HP action. If the harassment also qualifies as some of these other forms of illegal activity that I was talking about, you have the option of any of these things that are relevant to the type of harassment too, right? You could go to mediation over it. You could complain to the New York City Commission on Human Rights. You could talk to the Attorney General. You could go to the cops. You could go to small claims court. Hope that answers the question.
Does the landlord have a right to place a camera on a wall opposite my apartment door?
I wish I had included a slide about this and prepped for it a little bit more. Unfortunately, my response to this is the law on it is not as strong as I would like it to be. I have had multiple clients who've experienced their landlord spying on them. And getting the landlord to stop doing that has always been a major struggle. I would start with letters to the landlord firmly documenting the fact that this has happened and requesting that the landlord point the camera elsewhere. The law is going to say that the landlord has the right to have a camera, but does the landlord have a right to have a camera pointed at you or pointed at your door? Not necessarily. What's going to happen is that if you take it before a judge, if it, it'll get tied up in arguments over, is it specifically pointed at your door? And is that where it has to be? And a judge is not going to be that convinced unless you can prove that it's specifically pointed at your door and that the landlord could put it somewhere else. Uh, so I'm sorry to say it's an uphill battle, but I do believe that it's something that landlords should be held accountable for, and I think there's a chance in the law. Like certainly the law is open to it. Getting a judge to see it from your point of view might be a little bit difficult. And again, the best way to improve your case, as always, is to document as much as you can. And if documentation isn't an option, try talking to your neighbors to see if they're also experiencing things like that.
Okay, and somebody asked, is DHCR a better forum for harassment claim if one is looking for damages?
No, it is not. If a person is looking for damages, housing court is a better forum. Uh, if you're looking for civil penalties against the landlord, which would be paid by the landlord to the city rather than to you, then DHCR might be a better forum in that it's simpler, more straightforward, less involved. If you're looking for punitive damages paid to you, then your best chance of proving that you've suffered in a way that warrants those damages is in housing court, where you get to put on testimony and have multiple, you can have a hearing, you can have multiple hearings.
Okay, and then there were some, just to remember, the focus of this training will be about harassment. So if you have questions about good cause or anything like that, that's not the focus of this training. But I'm going to give everyone a minute more to see if anybody else has any other questions. I'm also checking the YouTube live chat to see if there's any questions. Um, but in the meantime, we do have some other workshops that are coming up. just to let you know. So we have a our night series is continuing. That's going to be on May 28th. But we also have repairs and abatements in non-payment cases, breaking leases, housing rights of immigrants, and access to shelter. No grounds holdover, overcharges, and deregulation risks that are coming up. We also have our old trainings, especially on like good cause eviction, um, that we have already done. And those old trainings are also on our web posted on our website, and this is the link where you could see all those trainings. Just to let everybody also know, we if you're a tenant or you have tenants, we also have weekly workshops for tenants. We have different topics per day, and some of them are after work hours. So if you have working clients, then it may be helpful to refer to this page, just so that it's a convenient time for them to attend. But otherwise, did you have anything else to add, Cora?
Um, just very quickly to the clarification on the good cause question, I was gonna say, you know, good cause is very new. The housing maintenance code is older. It doesn't specifically enumerate anything having to do with good cause reason, of course. But if something is happening that's a violation of good cause, that falls into the catch-all, which is here, repeated significant acts that substantially interfere with the peace and quiet of an occupant, I would say try it. I don't personally know of any cases yet where it's been tried, so I don't know. I can't help assess how successful it would be, but I would not hesitate to give it a go if you have the resources to do it.
Great. All right. I don't see any more questions, but thank you, Cora, so much. We definitely learned a lot, and I hope it helps everybody. And again, thank you to everyone who came out today on this beautiful Friday, and asking the questions. We all learn from each other, and everyone have a great weekend.
Thanks so much.